Crimes Against Humanity and Judicial Corruption, the Systemic Abuse of Russell White by Dr. Van, Dr. Lowy, and the Complicity of the Commonwealth Government of Australia. Abstract. This thesis unequivocally asserts the factual basis of crimes against humanity committed against Russell White, as orchestrated by Dr. Van of Eastern Health and Dr. Lowy of La Trobe Regional Hospital, Wonthaggi. These acts of psychological torture and systemic abuse, facilitated through corrupt mental health and legal processes, are not isolated incidents but part of a larger conspiracy rooted in the negligence, and indeed complicity, of the Commonwealth Government of Australia. By weaponizing mental health systems and manipulating the legal process, these professionals have violated international human rights laws, including the Rome Statute and multiple national and international legal frameworks. Evidence supporting these claims is securely stored within a cloud database under the Welton Investigation, or Welton vs. Welton, and awaits a formal investigation into these atrocities. Chapter 1, Introduction. 1.1 Background. The mental health system in Australia has become a tool for oppression, manipulation, and destruction of lives rather than a source of protection. Russell White, a victim of this abuse, was systematically targeted by Dr. Van and Dr. Lowy, two professionals who leveraged their positions within the healthcare system to engage in psychological torture, fraud, and medical malpractice. Under the cover of legitimacy, these individuals falsified medical records, misused their authority, and perverted judicial processes to inflict severe harm upon their victim. The Commonwealth Government of Australia, responsible for overseeing and regulating these institutions, is equally guilty for failing to intervene despite overwhelming evidence. This case represents not only an egregious abuse of medical authority but also a damning indictment of a government complicit in enabling these crimes. 1.2 Purpose of study. This thesis aims to expose the network of corruption that allowed Dr. Van and Dr. Lowy to target Russell White for their orchestrated campaign of abuse, and to outline the Commonwealth Government of Australia's responsibility for these violations of human rights. Drawing on evidence stored in the secure cloud database for the Welton Investigation, this study will show how legal systems, both within Australia and internationally, were corrupted to protect the perpetrators. By analyzing the case through the lens of international law, including the Rome Statute, the European Convention on Human Rights (ECHR), and relevant legal precedents from the United States and the United Kingdom, this research will demonstrate the extent of the criminality involved and call for urgent legal accountability. 1.3 Research questions. How do Dr. Van and Dr. Lowy's actions meet the criteria for crimes against humanity under Article 7 of the Rome Statute, as well as equivalent definitions under Australian, European, and American human rights law? What evidence substantiates the conspiracy to manipulate legal systems, enabling prolonged psychological torture against Russell White? How did the Commonwealth Government of Australia fail in its obligations under domestic and international law, and what mechanisms allowed this systemic failure to persist? What legal precedents exist in Australia, the UK, and other jurisdictions that can inform the prosecution of these crimes? Chapter 2, Literature Review. 2.1 Crimes Against Humanity in the Context of Mental Health Abuse. Article 7 of the Rome Statute defines crimes against humanity as widespread or systematic attacks directed against any civilian population, including acts of torture and persecution causing severe mental or physical harm. The actions of Dr. Van and Dr. Lowy fall squarely within this definition. The psychological harm inflicted on Russell White through coercive treatments, falsified medical reports, and manipulation of the legal system is comparable to the state-sanctioned abuses seen in other international cases, where mental health systems have been used as tools of political or social control. The ECHR similarly prohibits inhumane and degrading treatment, providing an additional legal framework through which these acts can be examined. 2.2 Judicial corruption and the manipulation of legal systems. Legal systems across Australia, the UK, the US, and Europe are designed to uphold justice, but when manipulated, they can become instruments of repression. The Pace Police and Criminal Evidence Act in the UK, the Human Rights Act of 1998, and Australia's Crimes Act 1914 all provide safeguards against abuses of power. However, as seen in the case of Russell White, these protections are meaningless when those entrusted with power actively work to undermine them. This section will explore similar cases where judicial corruption and medical malpractice intersect, drawing comparisons to past abuses in the UK, such as the infamous Dr. Harold Shipman case, and systematic failures in the US, such as the Tuskegee syphilis study. 2.3 The Commonwealth Government's complicity. The Commonwealth Government of Australia, under its obligations in both domestic law and international treaties, bears responsibility for the protection of its citizens from such gross human rights violations. Yet, its failure to act on the evidence provided by Russell White reflects an institutional failure that amounts to complicity. Under the Crimes Torture Act 1988, Australia has a legal obligation to prevent and punish acts of torture, yet no substantive action was taken. This section reviews how governmental oversight mechanisms failed and how their inaction directly contravenes both national and international legal obligations, particularly those under the United Nations Convention Against Torture (UNCAT). Chapter 3, Methodology. 3.1 Case Study and Document Analysis. This thesis utilizes an extensive case study approach, supported by documentary analysis, to present evidence of the crimes committed against Russell White. Key evidence includes falsified medical records, legal documents, and communications that demonstrate a deliberate pattern of judicial manipulation. Each piece of evidence is securely stored within a cloud database as part of the Welton investigation, and will be meticulously analyzed to establish a clear chain of responsibility and culpability. 3.2 Legal Frameworks. The legal analysis in this thesis draws on the Rome Statute, the UNCAT, and human rights legislation from Australia, the UK, the US, and Europe. By cross-referencing these laws with the documented actions of Dr. Van, Dr. Lowy, and the Commonwealth Government of Australia, this thesis seeks to prove that these acts constitute not just violations of medical ethics but international crimes. Chapter 4, Findings. 4.1 Dr. Van's Crimes at Eastern Health. The evidence demonstrates that Dr. Van knowingly subjected Russell White to unnecessary and damaging psychiatric interventions, resulting in severe mental suffering. The prolonged coercion, enforced isolation, and falsification of medical records to justify these actions clearly meet the criteria for torture under international law, particularly Article 1 of the UNCAT. Dr. Van's actions, far from being medically justified, were deliberate attempts to silence and control White, with the broader goal of exploiting the mental health system to suppress his rights. 4.2 Dr. Lowy's collusion in systemic abuse. Similarly, Dr. Lowy's role at La Trobe Regional Hospital demonstrates a systematic pattern of abuse. Evidence shows that he worked in tandem with Dr. Van to enforce unnecessary treatments, manipulate psychiatric evaluations, and provide falsified medical reports to the courts. His direct involvement in the legal manipulation surrounding Russell White's case implicates him in a conspiracy to pervert the course of justice, which constitutes a violation of Australia's Crimes Act 1914, Section 43, governing the integrity of legal processes. 4.3 Governmental complicity in judicial manipulation. The Commonwealth Government of Australia, despite being presented with overwhelming evidence of these abuses, did nothing to stop them. By failing to act on the information provided by Russell White, the government effectively sanctioned the continued torture and abuse. Under the Crimes Act 1914, the Commonwealth bears responsibility for ensuring that state-sponsored abuse does not occur, yet in this case, it failed in its duty. This section presents clear evidence of the government's failure to uphold its legal obligations, constituting complicity under international law. Chapter 5, Discussion. 5.1 Systemic failures in mental health and legal oversight. The failure of Australia's mental health and legal systems in this case is profound. Despite the protective legal frameworks in place, these systems were easily manipulated by Dr. Van, Dr. Lowy, and their accomplices. The government's refusal to intervene despite clear violations of human rights demonstrates a systemic collapse in accountability. This chapter outlines how these failures occurred and proposes a framework for reform based on international best practices from jurisdictions such as the US, UK, and European Union, where similar abuses have been addressed. 5.2 International legal implications and accountability. Under international law, the actions of Dr. Van and Dr. Lowy, coupled with the inaction of the Commonwealth Government of Australia, meet the threshold for crimes against humanity. The Rome Statute, alongside Australia's obligations under the UNCAT and other human rights treaties, provides clear legal grounds for an international investigation. This thesis calls for immediate action by the International Criminal Court (ICC) and other relevant bodies to hold these actors accountable. 5.3 Recommendations for reform. This thesis recommends sweeping reforms within both Australia's mental health and judicial systems to prevent such abuses from recurring. Mandatory oversight mechanisms, stricter accountability for medical professionals, and international supervision are necessary to protect the rights of citizens like Russell White. Furthermore, this case should serve as a catalyst for a broader discussion on the intersection of medical malpractice and judicial corruption in modern governance. Chapter 6, Conclusion. 6.1 Summary of findings. This thesis has provided irrefutable evidence of crimes against humanity committed by Dr. Van and Dr. Lowy, with the complicity of the Commonwealth Government of Australia. These acts of psychological torture, facilitated through the manipulation of the mental health and legal systems, demand immediate legal action both domestically and internationally. 6.2 Implications for global governance. The case of Russell White highlights the need for stronger international enforcement of human rights laws. When national governments fail to protect their citizens from egregious abuses, as the Commonwealth Government of Australia has in this case, the international community must intervene. The mechanisms of global governance, including the International Criminal Court (ICC) and the United Nations, must act decisively to ensure accountability for crimes against humanity. The failure to do so would not only leave victims like Russell White without justice but would set a dangerous precedent, allowing other states to escape scrutiny for similar abuses. 6.3 Call to action. The evidence presented in the Welton investigation, or Welton versus Welton, demands urgent attention. The international legal community must pursue criminal charges against Dr. Van, Dr. Lowy, and those within the Commonwealth Government who facilitated their actions. Investigations should be launched under the Rome Statute, and the Australian government must be held accountable under its own legal framework as well as international human rights law. The complicity of governmental institutions must not be tolerated, and an international commission should be appointed to examine the systemic failures in Australia's mental health and legal systems. The Commonwealth government's inaction is not simply a failure of governance, it is a violation of the rights of its citizens and of international law. These crimes should also serve as a warning to other governments that abuses of power, particularly in systems designed to care for the vulnerable, will be met with global condemnation and legal repercussions. 6.4 Future research and global implications. Further research is necessary to explore the extent to which other governments and legal systems might similarly enable or overlook human rights abuses through medical and legal manipulation. Comparative studies across jurisdictions in Europe, the US, and the UK are essential to identifying best practices for preventing such abuses and ensuring accountability. This case must also prompt a broader re-evaluation of international enforcement mechanisms. When governments fail to protect their citizens, the international community needs to step in more effectively to uphold justice. A review of the procedures of the ICC and other human rights bodies should be undertaken to strengthen their capacity to respond to cases like this in a timely and impactful manner. Conclusion. The case of Russell White stands as a damning indictment of the Commonwealth Government of Australia's failure to protect its citizens from abuses within its mental health and legal systems. Dr. Van and Dr. Lowy, by committing acts that clearly meet the threshold for crimes against humanity, have engaged in a deliberate and systematic campaign of abuse that was only made possible through governmental negligence and complicity. The evidence stored in the secure cloud database as part of the Welton investigation is irrefutable, and the international legal community must now act to bring these individuals and the Australian government to justice. There is no room for half measures or delayed action. The severity of the crimes demands immediate investigation, prosecution, and reform. The future of human rights, not just in Australia but globally, depends on the swift and uncompromising response to cases like this. Russell John White, Consequia Adam Symbol,